Okay, it's just 3 o'clock now, and so I think we got a pretty jam-packed agenda, so I think we'll get started. So good afternoon, everyone, and thank you for joining us. So today's webinar is titled Health and Safety Challenges, and we're going to talk about the Sudbury case, increased fines and due diligence. Before we begin, I just want to do a land acknowledgement. And so I'd like to respectfully acknowledge that we are situated on the traditional territories and treaty lands, in particular those of the Mississaugas of the New Credit First Nations, as well as the Anishinaabe of the Williams Treaty and the Huron-Wendat and Métis Nations. As the ResCon office is located in Vaughan, we are grateful to have the opportunity to work and live in this territory. Just a couple of housekeeping items. As always, our webinars are recorded, and we do send emails out with the slide decks that are attached to it. And so we will do that again as we always do. Also, a big part of today is not only the presentation from Louisa, but also a question and answer segment. And so if you do have questions, please use the question and answer function, which will allow us to interact with you and get the questions primed for Louisa. So I think that's good. So today's webinar is about health and safety. And as builders and as people in the residential construction sector, we do not like uncertainty in any part of our business. We certainly don't like it when it comes to health and safety. And with that, we don't like surprises. And so I think it's safe to say that the Sudbury case was a surprise, the decision. And so that's why we're here today. We're here to understand exactly what happened and how it's going to impact the residential construction sector. In addition, it's a good opportunity to also talk about increased fines. That's something that we've been talking about as a membership and through the Health and Safety Committee. And then finally, you can't have a conversation about health and safety without talking about due diligence. And so the idea is at ResCon and through the ResCon Health and Safety Committee, which I'm very thankful for and does incredible work, we're always trying to make sure that members have the resources that they need to make sure their workers are safe. And so part of that is understanding the regulatory environment, understanding what best practice exists, and how do we create, implement, and self-enforce the policies that we need to make sure that our work sites are safe. So with that, I'm going to take an opportunity to introduce our speaker today. So Louisa Viknovich is not new to ResCon. I think we got to know her as a membership during the COVID era, and so she was kind of one of our pioneers that helped get us into the webinar series. She specializes in all employment law, but certainly has a specialty when it comes to health and safety. But more importantly, she can give legal advice, but she can also give practical advice, and she's able to interpret and discuss the law in a way that makes sense to the residential sector and our members. So without further ado, I'd like to turn it over to Louisa.
Thank you so much, Andrew, for that warm introduction. And it's such a pleasure to be here to speak with you all today. I know COVID was certainly an uncertain time. It feels like the uncertainty is continuing, at least with the tail end of what's happened in the health and safety front from both, the case law and the legislature, including from October onwards. So the goal of today, I'll get the presentation going and I'll walk us through some of those changes. There we go. Can you see that okay? Yeah, perfect. Okay, great. So let's get started. I'll jump right in. The first thing that we're going to be taking a look at very quickly is Bill 79, Working for Workers Act 2023, which gets us started with a discussion about the turbulence with the increased fines from the legislature. Then we're going to look at the all-famous RV Sudbury, which has stirred quite a commotion, I think, particularly in the construction industry. And then we're, of course, going to be looking at best practices, as Andrew mentioned, with respect to due diligence. When there's so much uncertainty, I think it's good to come back to what we do have control over. And I think that's what warrants the due diligence discussion. So with that, let's jump straight into increased OHSA fines. So Bill 79, Working for Workers Act, received royal assent, came into force and effect October 26, 2023. The maximum fine for a corporation on conviction of an offense under the Occupational Health and Safety Act is now increased to $2 million per count. And that's an increase from $1.5 million, which was the prior penalty previously, the maximum. And of course, this is part and parcel of a series of amendments and trends that we've seen going back to 2017 and then again in 2022. And so we're going to take a look very quickly at some of those trends. So back in 2017, we saw a very significant jump for corporations from $500,000 as a maximum fine amount on conviction to 1.5 million, which is of course now increased to 2 million with respect to any kind of offenses that are made out under the Act post October 26, 2023. Fines in 2017 were also increased 4 times for individuals, from $25,000 to $100,000. Then we saw increases in 2022. For directors and officers of a corporation, the fine amounts increased from $100,000 to 1.5 million. And again, these are maximums. There are no statutory minimums, but still a signal from legislature, I think, and certainly there's been commentary in case law of a desire from legislature to see the ministry imposing higher amounts when seeking convictions. Also, $500,000 for all other individuals, which was the increase from $100,000. In 2022, we also saw a couple of other things as a result of Bill 88, as it was then, with the limitation period being extended to 2 years. So, of course, previously the Ministry of Labour had 1 year to lay charges. That's since been increased to 2 years. And we saw codification of aggravating factors. So factors that can be considered in sentencing, which we saw in the case law, have now been incorporated into the Occupational Health and Safety Act. So, for example, prior convictions and things like that will now be considered as an argument for why amounts on conviction should be increased for additional offenses under the Act. So where does that leave us? Because there's been so many changes. That leaves us with $2 million as the maximum fine amount for a corporation, 1.5 million for a director or officer of a corporation, and $500,000 for all other individuals. We still have our 2-year limitation period, and aggravating factors, which are now, of course, considered on sentencing. They've always really been considered, but now it's a bit more formalized. The one thing that I will flag is that these amounts are per offense, and as always, there is a mandatory victim fine surcharge of 25%, which is a kind of court-imposed administrative fee that's non-negotiable and is usually added on to any amounts that are pled guilty to. So with all of that in mind, we had kind of that going on from our legislature. Now we're looking at the case law because there's turbulence there as well. RV Sudbury is a decision that dealt with several offenses under the Occupational Health and Safety Act. It was heard by the highest court in Canada, the Supreme Court of Canada, a couple months ago in October. The decision came out in November, and it caused commotion in the construction industry in particular, and specifically with respect to what this means from a liability perspective going forward. Before we really dig into the decision, I think it's important to just take a step back and lay some of the groundwork, some of the foundation to really understand the implications of the decision. So what I'm going to do is I'm going to start us off with kind of a quick overview and recap of an act that I'm sure many of you are familiar with, the Occupational Health and Safety Act. And specifically, I'm going to take a look at Part 3 of the Act, which is reproduced for you on the slide there, and just outlines kind of some of the key actors that are captured and considered under the legislation. So you'll see 3 that are highlighted there for you. Constructor, employer, and owner. Certainly the Act considers duties and responsibilities of many other actors, but for the purposes of understanding this decision, I think those are the 3 key roles that we really want to concern ourselves with. And so the Occupational Health and Safety Act, as many of you know, sets out the measures and procedures that are required for work sites across Canada, or pardon me, across Ontario. And that includes construction and non-construction. And those specific measures and procedures we can see with respect to the regulations under the Occupational Health and Safety Act, and of course the duties that are outlined under Part 3 correspond with the regulations, and so it's really meant to be read as a whole. So when we look at these 3 roles that we highlighted for you, the constructor, the employer, and the owner, it's important to just unpack what those roles actually are and how they're defined under the Act. So the Act defines an employer as what you see on the slide there, but I will read it out. It's a bit of a mouthful. An employer means a person who employs one or more workers or contracts for the services of one or more workers, and includes a contractor or subcontractor who performs work or supplies services, and a contractor or subcontractor who undertakes with an owner, constructor, contractor, or subcontractor to perform work or supply services. It is a very lengthy definition. Hopefully, the Court of Appeal for Ontario back in 1992, in a decision called R.V. Wyson, just distilled the definition into essentially kind of one of two camps. An employer is a person who employs a worker or who contracts for the services of a worker. And that decision, just by way of background, was pretty important because what it essentially said was, you can't contract out of your liabilities under the Occupational Health and Safety Act as an employer by virtue of hiring an independent contractor. So the real key point of that decision was to say, as an employer, it encompasses the traditional employer-employee relationship, but the independent contractor relationship as well. That's an important piece of context for what we're going to get to with this decision. Constructor is defined as a person who undertakes a project for an owner and includes an owner who undertakes all or part of a project by himself or by more than one employee. This is important because if you're labeled as a constructor, constructor is typically seen as the actor with the greatest degree of control on a construction site. Ultimately, the constructor is responsible for the health and safety of every project, and every project has a constructor and an owner. So it's always interesting to see the dynamic between the constructor and the owner, and how much the owner wants to get involved and retain portions of the constructor role on a job site, on a project, versus really just taking a step back and hiring a constructor to kind of take the reins and go forward. And that has really important implications as well in terms of the duties and the roles that both entities play. Lastly, we're going to look at the definition of owner, which includes very straightforwardly a trustee, receiver, mortgagee in possession, tenant, lessee, or occupier of any lands or premises used or to be used as a workplace, in a nutshell. Really importantly, there is a limitation on what can be or who can be defined as an owner. And specifically, an owner does not become a constructor by virtue only of employing someone to essentially perform quality control. So whether that be an architect, an engineer, or any other person. Note that the legislation doesn't have that same carve out for the ability to be found an employer. So we don't see a similar limitation in the legislation that says an owner does not become an employer by virtue of essentially engaging in quality control practices. We only see that limitation with respect to a constructor. And I think that's pretty pivotal when we look at the analysis and the decisions here. Again, why do we care about these labels? These labels directly inform the duties that each entity is supposed to play on a job site. And that's why the uncertainty is such a sticking point for us, right? There's different levels of accountability, and consequently, there's different levels of liability when it comes to who is responsible for doing what, and who do we point the finger at if something goes wrong. And just to kind of show you how much these provisions mirror one another and to some degree are removed, you can take a look at Section 25(1)(c), which talks about the obligation of every employer to ensure measures and procedures under the Act are carried out. So, for example, think about your construction regulations that set out, as an example, the use of fall protection equipment. An employer must ensure that fall protection equipment is used on site and used properly in certain circumstances. Whereas a constructor must ensure that every employer on the job site is carrying out the measures and procedures. So we see the duties set out, just a slight nuance with respect to how those duties are set out and how they're carved out. So let's get into the meat and potatoes. Let's get into what actually happened in this decision. Now that we have that background, I think we're ready to have a discussion about it. So like most municipalities, the City of Sudbury is responsible for maintaining roads in working order and in good condition, and that's pursuant to its own legislative requirements. Back in about May of 2015, the City of Sudbury commenced road work to repair a water main and to repave streets on one of its roads. In order to do that, it hired Interpaving Limited. It contracted for Interpaving to specifically act as the GC on site and to assume responsibility for the performance of work. Interpaving used its own employees to perform the work. But the key fact in this decision is that the city still hired two individuals to act as kind of quality control inspectors that would attend and regularly surveil the construction zone, the construction project, and report back, specifically as to the status of the project and, of course, as to the quality of the work being performed. What's also important to note is that this road was in a construction zone that was adjacent to public spaces. So just across the street from where the incident happened, you had a retirement residence. So a couple of months after the project had started, I think it was around September 2015, a 60-year-old woman was crossing an intersection, and very tragically, an interpaving employee that was operating a road grader operated the road grader in reverse and struck and killed the pedestrian. And the ministry naturally commenced an investigation to understand what led to the incident and found several offenses, several breaches of specifically construction regulation 21391 under the Occupational Health and Safety Act. So there were two kind of fundamental breaches. The first was that there wasn't a fence in place to guard off the construction area from the public space. And by regulation, specifically Section 65, there was a requirement to have a fence of about 1.8 meters erected to section off the public area from the construction zone. And also there wasn't a traffic plan. There wasn't a signaler in place. Typically, we see under the construction regulation a requirement to minimize, if not entirely remove, the requirement to operate machinery in reverse. To the extent that it can't be limited, where it is required to be operated in reverse, there's a requirement to have a signaler present if there is an immediate danger posed to members of the public. And so naturally, both of those offenses, the ministry felt they could make out beyond a reasonable doubt. They charged both Interpaving and the City of Sudbury as employers under the Occupational Health and Safety Act. The city was also additionally charged as a constructor. So what happened next? At the lower levels, we saw the city concede to being an owner for the purposes of the Occupational Health and Safety Act. And remember, just a moment ago, we looked at that limitation about if you are an owner, you aren't naturally going to be found a constructor by virtue of only hiring quality control individuals on site. And so because of that limitation, the lower court found the city was not a constructor, right? It had that legislative limitation that it could rely on. The question was at that point whether or not the city was an employer. The city disputed that it was an employer. It said it wasn't in control of how the GC's, so Interpaving's employees were performing the work. And at the trial level, the court agreed. So the JP agreed, said that the city is an owner, but neither a constructor nor an employer. And quite simply put, the city lacked requisite control. So it agreed with the argument that the lack of control over Interpaving's employees would kind of necessitate the finding that it was an employer. So it agreed with that. What happens next? It goes up to the Ontario Superior Court of Justice, which reinforces the Justice of the Peace's outcome. The one thing that I'll add as well, it was a quick kind of aside and at this point opener, but the trial level, the JP did mention in the case that it was wrong in the outcome that the city was an employer, it found that the city in any event exercised due diligence. And so ultimately this goes up to the Court of Appeal. The Court of Appeal overturns the lower court's findings. And the Court of Appeal decision is ultimately what I think the state of the law is in Ontario. So the Court of Appeal finds the city was an employer for the purposes of the Occupational Health and Safety Act. And it takes a step back. It takes a look at the legislation and it says, if you look at the Occupational Health and Safety Act, if you give it a broad and generous interpretation, and you really look strictly at the definition of employer, and you consider again the Court of Appeal's prior decision back in 1992 in Wyson of the employer being defined as someone who employs a worker or who contracts for the services of a worker, the Court of Appeal finds, well, technically, the city did employ a worker. So the two quality control folks that were on site were the city's employees. And so on a very strict reading of the Occupational Health and Safety Act, the city meets the definition of employer, full stop. And so that's where the Court of Appeal lands on that. They specifically note the fact that that section 1 sub 3 exemption of an owner not being found a constructor doesn't apply. There isn't that similar exemption for an owner not to be found an employer under the Act. On the question of due diligence, and this is the sticking point for me personally and a sore spot, the Court of Appeal remits the decision on due diligence back to the lower court. So we don't actually have an answer on whether or not the city exercised due diligence and had a due diligence defense available to excuse itself from the offense. There's an open and live issue as to what is sufficient to amount as due diligence from the city's perspective. So the city had kind of taken the position that, look, before it hired Interpaving, it did its original pre-screening, the same process that it usually undertakes before hiring constructors. That was sufficient to amount to due diligence. The Crown took the position that no, that's actually not enough. And what we're looking for when we're establishing a due diligence defense are specific acts of due diligence. So the fact that the city would have turned its mind to how this incident arose, the specific requirements under the construction regulation, and what measures it took to prevent an incident occurring by violation of either of those offenses. And so we don't have an answer on that besides the obiter commentary of the JP that was originally provided. That's going to be decided at some point. What happens next? The decision goes up to the Supreme Court of Canada. It's appealed again. And although we usually have an odd number of folks, of justices at the highest court in Canada, unfortunately, 9 judges heard the case, but only 8 judges issued a decision. And that's due to a whole host of factors that aren't necessarily relevant to this decision, although there was some gossip about the conduct of one of the judges and perhaps that leading to his subsequent removal from the bench. So that's something we can chat about at another time. But ultimately, what we're left with are 8 justices who issue a decision. And you'd think that they would split somehow in an odd fashion and give us a majority ruling, but unfortunately they're dead center. And so we have a 4-4 decision. We have judges kind of parting ways in Camp 1, which find that the city is an employer. They uphold the decision of the Court of Appeal for Ontario. And they kind of elaborate on the Court of Appeal's decision. They say, look, at since 1970, when we've looked at the Ham Commission report and the original legislative reform of the Occupational Health and Safety Act, we've always talked about this internal responsibility system, the fact that there are overlapping duties on a job site, the fact that no one should be able to point the finger at another actor on a job site and say, well, I thought they were taking care of those obligations. The idea is everyone has a role to play and everyone at the end of the day is ultimately responsible. The level of control over workers and how they're performing work isn't relevant for the purposes of finding someone to be an employer under the Act. They also kind of include this commentary, though, that the level of control might still be a relevant factor for the analysis under a due diligence defense. So that's something we're going to talk about in a moment. But for the purposes of being found an employer, they say not relevant. The other school of thought, so the other camp, we have a group of 4 judges that say, no, the city isn't an employer of Interpaving's employees. And the whole idea when we go back to Wyson was simply to say that you can't contract out of liability, if you have an independent contractor. But you as an employer shouldn't be responsible for the independent contractors or employees of another employer. That's kind of an absurd outcome. That's not what would have been contemplated by legislature. And they say, this result basically suggests that everyone who employs anyone would be responsible for everything that anyone does on a construction site, which leads us to kind of a crazy result and an outcome. So what are we left with? Well, because it's a split decision, the outcome from the Court of Appeal for Ontario is still the law for the purposes of kind of Ontario. And the fact that, nowadays an owner, I think it's formally understood, an owner of a project site, of a construction project site, can be found an employer for the purposes of the Occupational Health and Safety Act, which means that all of the duties of an employer would likewise apply to an owner. So in the land of uncertainty, because of course now we're concerned, we're wondering, well, what does this mean, right? How am I going to be found an employer versus not found an employer? Does this mean that I don't want to, as an owner, maybe hire folks to do quality control on site or to do any kind of measures on site? Maybe I want to take a step back now to avoid being found an employer for the purposes of the act. I think it's really interesting to see how individuals are going to react to this. I don't know, when I look at it in the balance of kind of what measures we should be taking to protect health and safety on construction sites, I don't know that that's the right answer. I think because we have the Court of Appeal simply saying, they employed workers on the job site and that landed them the definition of employer, we don't know whether or not they would have been found an employer under the second portion of that definition. The Court of Appeal is silent on that. And so even avoiding being found an employer by not hiring anyone to do quality control on a job site, well, we don't know if that would be enough to later have an argument that you weren't in any way responsible for an accident that happened on site. And so when that happens, of course, you run the risk of not having taken measures to establish a due diligence defense. And so I think when we have so much uncertainty, the one thing that we do have control over is revisiting what practices we currently have in place from that due diligence perspective. What can we tweak? Maybe it's an opportunity to audit, see where we are in our life cycles, right, with the existing health and management, safety management systems that we have in place, and what can we do with that going forward. So level of control, as I mentioned, is still a relevant factor when demonstrating due diligence. I think that's what we're left with, even when we look at the Supreme Court of Canada commentary, right? So as an owner, I might not be expected to go to the level of due diligence as the direct employer of a sub-trade who's involved in performing that work. Maybe I don't have the same level of expertise to really appreciate and understand, the level of risks posed by the work being performed. But perhaps I might be able to establish a due diligence defense as an owner by saying, well, I did my pre-screening. I checked off all the boxes in terms of asking the right questions, looking for the adequate paperwork in terms of certifications and qualifications and all of that. So kind of in terms of a checklist, if we were to distill what we can do, I think the starting point is hazard assessments. This is really fact specific, right? When we look at construction sites, it's so fact specific in terms of the scope of the work that's being performed and the unique hazards and kinds of equipment and hazards associated with that equipment that might arise as a result of the scope of work. But kind of as a very general broad overview, start with the hazards, consider who you're going to need to hire as an owner to perform the work. And then think about, the constructors that you're hiring, their contractors, their employees. What qualifications do they have? What can they demonstrate to you at the outset to show you that they're fit to perform the work? As an owner, if you're working with a GC for the first time, consider the financial viability of the company, right? That's usually one indicator in terms of are they tracking KPIs? Are they do they have WSIB in place? Are they able to give you the insurance, the clearance certificates, all of that? Are they able to talk to you about their compliance efforts? Do they have safety management systems in place? How are they auditing and tracking their internal performance? These are all the things I think you want to turn your mind to as a pre-screening metric. But then, of course, once you've actually hired or retained these parties, I think the line that we're towing is how involved we want to be in terms of, do we really want to backseat drive too much at the risk of being found an employer? And again, I don't think there's a clear line there about when you will or won't be found to be an employer for the purposes of the act. But again, from the perspective of due diligence and making sure you're putting your best foot forward to avoid liability, I think you do want to turn your mind to, are you monitoring when issues are coming up on site and how they're being addressed? Are you putting it back to the constructor and asking them to go back and fix any compliance issues? Or are you intervening, right? These are all things that can lead in the future to, potentially you having employees on site and therefore meeting the definition of employer. But I think when you're looking at that balance, it's better to err on the side of caution to keep your due diligence efforts and to perhaps revisit and revamp them. So with that, I'm gonna turn it over back to you and see if you have any questions or anything that we can kind of further unpack with respect to the discussion.
Perfect. Thank you so much, Louisa, for that very informative presentation on the Sudbury case. So we are going to have a question and answer period now, and we're just going to jump right in. I do have some questions coming in already. So the first question is, can my employer pay my fine as a director or an officer of the corporation or under the all other individuals?
So that's a great question. Individuals technically are responsible for their own fines. Okay, so I will say any fines that are imposed on the individual. Technically, there's nothing preventing an employer from being able to reimburse an individual for a fine under the Occupational Health and Safety Act. I don't think there's any kind of internal auditing that happens. I think that's very much a discussion between the employer and the supervisor, for example, that might be charged, or the director or officer. But what I will say is that the fine amounts, again, are intended for the purposes of general deterrence. And so, technically speaking, it should be the individual paying, but there's certainly that caveat.
So just a follow up to that one, who would count as all the other individuals?
Yeah. So when we're looking at the individuals, we're going back to that Schedule 3 that I showed you a screenshot of. And I've stopped screen sharing, so I don't think I can come back to that slide. But just kind of quickly thinking about supervisors, directors, officers, there's a whole host of different actors under there. And that's who we would be looking at as any individuals, unless they're already covered for under directors and officers.
Perfect. And has anyone been fined yet under these provisions?
Yep. So it actually happens quite often, more often than you'd think. And I think a really helpful decision that illustrates it comes from the Court of Appeal for Ontario. I believe it was 2019, a decision called New Mex Canada. I can definitely circulate it afterwards. So just very quickly, that one is a non-construction decision. It happened in an industrial establishment out in Brampton. And it was pretty egregious. So it was 2 directors and officers who were fined. And it was with respect to an employee, a worker who unfortunately, it was also a fatality. This was a worker who had known epilepsy, and it was known to the directors and officers who were also this individual's supervisors. And they had the worker working from heights on an elevated work platform. Which, in hindsight, when the court's analysis unpacks it, right, it can be seen as pretty egregious as a decision in terms of what they permitted the worker to do. So I think it makes sense why we see the charges imposed against the officers of the corporation, in addition to a fine amount that was imposed against the corporation as well. What's really interesting in that one, and something that we need to be mindful of, because I know we didn't touch on it here, was in addition to fines, there's also the ability of a court to impose sentences, right? Like jail sentences, so incarceration on individuals. So that includes jail time of up to 12 months. And it can either be jail time, it can be a fine amount, or it can actually be a combination of both, as well as even prescribed orders, which we haven't seen a lot of. I don't think I've seen any decisions really on that front. But I do want to flag it for you, because since Bill 88, the court now also has discretion to issue all kinds of unique orders, depending on the circumstances. So in this particular case, the directors and officers ultimately didn't have to serve jail time. It was appealed a couple of times. And that decision to reinstate jail time, ultimately, the Court of Appeal didn't go ahead with it. And I think that has to do with a number of things, including how much time had passed between the offense and when it was ultimately heard. But I think it's something that we should all be aware of in terms of a very realistic possibility in terms of the kinds of ranges of outcomes from these accidents.
Perfect. Thank you so much for that answer and for the example as well. It definitely helped everyone understand a bit better. So moving forward, 2 fines were issued in the London, Ontario case where a mid-rise building collapsed. Do you have any comments on that case?
Yeah, so this was a case that happened out in London, and I believe it was back in 2020. And we had, I think, 2 fatalities that came out of that, and a number of individuals who were critically injured. And I know that decision with the fine amounts has been making its way right now into articles online. I know there's been a bit of commotion, I think, around that. And I think there's a lot of questions, and rightly so, when we look at Bill 79, which just said that there's an increase to fines for corporations, a maximum amount now of 2 million. And so folks are wondering, if the total amount, I think in this case against both employers was around 400,000, I believe that was the total fine amount. How do we reconcile that with, legislature signaling of increased maximums? And I think the answer to that is we have to look at when the legislative amendments came out. So at the time that this offense had actually occurred, we were still under the prior legislation. So we were still looking at $1.5 million as a maximum. And I think it's taking some time, despite the fact that legislature keeps increasing these maximums. I think it's taking some time to see kind of a more aggressive stance from the ministry in the way it's prosecuting these cases going forward. And certainly, right, when we have employers that are willing to take early resolutions and to plead guilty and demonstrate remorse, I think those mitigating factors are having some effect on the amounts that we're seeing with the fine amounts imposed as well.
Thank you. The next question is, how does, if at all, the City of Sudbury case impact a builder or their client when they work as a construction manager versus a general contractor?
Right. So there's not necessarily a direct impact. So I would say the due diligence kind of defense standards might vary a bit based on whether or not you have someone working as a construction manager versus a general contractor. So with a construction manager, the role I'd say is a little bit more on kind of advisory services and a pre-con perspective. So really more consulting. There's some level of responsibility when you're involved at the front end in terms of, anticipating the kinds of hazards that might come up on a job site and how the work might need to be conducted, but it's less hands-on. I think when you're in that general contractor realm, you're dealing with a more sophisticated site where it's usually involving multiple parties. The owners are usually retaining a bit more control over the way in which the project is being managed. And so I think when you're in that realm, the one thing to be mindful of, as a general contractor, is that, the owner could be taking a hands-off approach, in which case, you as the general contractor are entirely responsible for how the work is being conducted. I think it's fair to say, on my read, that we're going to see owners pushing for kind of more checks and balances up front, more paperwork up front, more screening measures that GCs are going to have to sign off on, kind of more red tape, so to speak. I think that that's probably a fair expectation to see with owners that are taking a hands-off approach. Whereas you might also see owners that are still now taking the opposite approach. And because, they're saying they're biting the bullet and saying, I might be found an employer anyways, I might as well be more active on site. I think the one thing to be cautious of if they are taking a hands-on approach is that you as a GC can't then take a step back and say, well, I'm good. They're taking care of it. They've thought through our obligations. They're checking it out. I think you still want to continue exercising due diligence and not become reliant or dependent on the owner's involvement on site.
I do agree. I think due diligence is one of the main things to come out of this case. So moving forward, as part of my company's due diligence process, we require subtrades and contractors to follow the Occupational Health and Safety Act. What are the best practices with respect to due diligence?
Okay. So I think just to kind of maybe spend a bit more time, I know we covered it briefly on the last slide. So look, a meaningful due diligence discussion is always going to be, as I mentioned, fact specific, unique to the workplace, and the site specific hazards associated with the project. I think the best place to start is really to conduct kind of like a scope of work hazard assessment. So consider your site specifically, what's being done, right? Are we going to have individuals performing work at heights? Are we going to have excavation on site? What are the unique hazards that are present on this job site versus any other job site perhaps that we've worked on previously? And I think that that's going to inform the approach going forward to who's going to be on site and what they have in place to anticipate those kinds of hazards, and their compliance efforts, right? So again, going through that screening process, looking at the GCs, asking them what they have in place. And then again, the discussion really is about monitoring going forward, the degree of, with spot checks, for example, or using safety consultants. Are you simply relying on information that's being reported back to you? Or are you getting involved? Are you having your employees on site? I think these are all questions that are, it's hard to have a conversation about this in the abstract. But what I will say is, we're going to hopefully get some more guidance from the lower court on how much is enough from a due diligence perspective, depending on what actor we are in on a project site. We'll see if that decision is also delayed. The other thing, and just to go off on a quick tangent here, the other bit that's interesting is that so the city actually decided to file a motion to the Supreme Court of Canada, because the decision split, to have it reheard. And I believe they filed that back in December. So there's a chance we might even get a decision back from the Supreme Court of Canada, if they decide to rehear this, that does land one way or another, as well. So I think all of this is to say there's a lot of uncertainty right now, even in the due diligence discussion. Keep doing what you're doing, the things that you have in place. Keep asking yourself what's working. Keep asking yourself what isn't. And I think that's it for now, and just hang tight and wait to see how this plays out, both with the lower court decision, hopefully, and TBD on the SEC decision.
So we do have another question kind of regarding due diligence again. So what is the best due diligence for when an owner does not want to follow the health and safety of the hired GC and allows their own workers into the construction zone? So for example, store retrofits with construction and industrial workers coming in.
So again, I don't think that there's necessarily a rule. I mean, subject to the kind of business relationship, there's not necessarily a rule preventing you deciding to kind of follow or implement your own standards on site. Obviously, that's something that's nuanced, and you need to navigate the various rules there and how that'll go over. But certainly from a compliance perspective, if you see things and you see room for improvement, I think it's important to raise that with others on site. But to the extent that you can kind of prevent an accident from happening by taking things into your own hands, I don't see any reason not to.
Would Sudbury still be liable if they had no one attend the site on their behalf?
And that's the question, right? That's what we're left with, because when I go back to Court of Appeal for Ontario, all they said was Sudbury is an employer because it had two individuals on site. What they're silent on is whether or not Sudbury would have still been an employer because it hired interpaving. Like when we go back to this definition of employer, right, of someone who contracts for the services of another worker, do they meet that definition just by virtue of having hired interpaving? So it's such a bang on question, and I wish I had the answer for it, but I feel like the case law left us with a huge question mark on that point.
Yeah, I think a few of the questions are all kind of following that same one regarding, did the firm providing the inspectors in the Sudbury case also attract any liability?
Did the firm provide? So I don't think that that's unpacked in the decision, but I think these are all valid questions that kind of are part of this uncertainty, right? Like there is an argument to say that if you are an entity that provides employees or workers on site, you could meet the definition of employer. Look, like when we go back to the legislation, I think in some respects, it's always been understood the Ministry of Labor could lay charges against an owner as an employer, right? It never had that same carve out for constructors or for employers as it did for constructor. But I think it was always this unsaid understanding that the Ministry of Labor really wouldn't exercise that discretion unless there was something site specific that contributed to the incident, right? So technically speaking, that ability has always been there. I think the uncertainty is sparked by the fact that, in this particular case, is this really the appropriate case for this? Like, is the city really exercising a certain level of control that would have contributed in some way to the accident? And I think that's one of the live questions.
So are there different rules for public or private owners? For example, the City of Sudbury or a pension fund or other private investor?
So the decision, I don't think actually goes into, like, it doesn't really delineate between public versus private owners, but I don't think it would be a surprise to see public owners taking more of a hands-off approach, and certainly implementing more red tape and more bureaucracy in terms of the screening processes. I think that's a likely outcome from this. But I don't think that we're looking at, higher liability necessarily for public versus private construction or owners of a construction site.
I think we have time for maybe a couple of more. So does the sophistication or complexity of the safety system play a role? For example, it is widely understood that a signaler needs to be present and that a construction zone needs to be blocked off from public access. However, if the accident has been caused by an equipment failure or series of events that is harder to prevent, how would this have changed the outcome?
So I think we need to go back to the starting point, which is the Court of Appeals decision, right? Which ultimately says, look, on a very strict reading of the Occupational Health and Safety Act, you're an employer by virtue of having employed a worker at the site. And level of control over the way in which work is performed doesn't necessarily factor into the decision of whether or not you're an employer for the purposes of the act. Something that wasn't mentioned in the decision, but I think is actually helpful to know, and it kind of came out in evidence. About 10 minutes before the accident had actually happened, there was surveillance footage of the two quality control inspectors having walked through the intersection, actually almost exactly where the incident had occurred. And I think it would have been really helpful if that was in the decision, because I think at least it would in part explain, how that might have played into the decision making, right? In terms of it starting to look more like the city was exercising control over the manner in which work was performed. I'm coming back to this because, like, if I look at the sophistication or the complexity of the safety system, like what ultimately went wrong, in this case, it wasn't caused by, some sort of a mechanical failure. This was caused by, again, two key pieces not being in place in terms of guarding off the public from the construction zone, right? This is something that I think the city could be seen as having some understanding of. It's quality control folks having some understanding of. A mechanical failure or something very unique, I think it's harder to say that something like that, we would look at this situation as being within the control of an entity that really has no specific experience or sophistication in that particular subject, right? So, like, practically speaking, would that have played into the decision making? Maybe. I'm speculating, right? I don't know. But I think, like, when I go back to the evidence and I think about, again, those two QCs being right there where it happened, I think that's maybe how we ended up here, right? Because if the Crown has this discretion that it could exercise in certain cases, even though we're told level of control isn't a factor in being found an employer, maybe this was why, right? Maybe this is the reason why the Crown decided to exercise its discretion in this particular case to lay those charges against the city, right? It's all speculation, but I'm just throwing this out there to say, it could have changed things, I think, if it was a mechanical failure and something that the city would have been outside of its scope of work or expertise.
I think we have time for one last question. Was interpaving COR or ISO certified, and would that have had an impact on the decision?
It's a great question. I do not have the answer to that off the top. I don't know. I could look into that. I don't actually know whether or not they were. I think if they had some sort of a safety management system in place, obviously, I mean, you would hope, right, that they would have been auditing, they would have caught that sooner. Maybe they would have been more likely to have addressed the issue. Perhaps it could have prevented the accident from happening. I don't know. But what I will say is I think it's still, irrespective of that fact, I think we should still be looking at these safety management systems as being a really important factor in the reduction of incidents on site, and something that we should be looking at just separate and apart from any kind of liability questions, but just more so because we know it's proven just based on statistics, right, and reducing accident rates on site.
Perfect. Thank you so much, Louisa. I am going to pass it over to Ahed now for some closing remarks.
Thank you very much.
Thank you very much for being with us, Louisa, once again. It's always great to have you here with us. So just a few last notes before we conclude the webinar. We've included a very short post-event survey that should pop up once you exit the webinar. So just please take time to fill it out. It is an opportunity to hear about what you guys thought of the webinar, maybe certain topics that you're interested in. And then if there were any last-minute questions that you didn't get a chance to ask, you can just put them in that survey. It shouldn't take longer than 45 seconds. And then the second thing is that this webinar is recorded. We'll be sending it in the post-event summary that should be going out in the next few days. And we're also going to upload it to the ResCon webinar under the events tab. So coming up next, we have another health and safety related webinar. It's titled Digitizing Your Health and Safety System. We'll be talking about a specific system that ResCon is aware of and the benefits of digitizing health and safety. It'll be on February 1st from 1 to 2:30 p.m. We were also going to include the link to that webinar in the post-event summary, so stay tuned for it. Thanks again for joining us and stay safe.